This is Real News Media TV, coverage you can trust. Please like, share, subscribe, and hit the notification bell. Select all for daily news updates. JDF Sergeant in custody following woman's death. A Jamaica Defense Force sergeant is now in police custody as a probe commenced into the killing of an unidentified woman on Caledonia Avenue, Kingston 5 on Saturday, February 26 unfolds. The body of the woman appears to be in its late 30s, is about 5 feet 2 inches long, and has a skin tone that shows evidence of bleaching. It was clad in a black blouse, a purple sweatpants, and 1 foot of black and red Nike sneakers. Reports from the St. Andrew Central detectives are that about 4:20 a.m., the Crossroads police responded to an assignment of a motor vehicle collision. On arrival of the team, a gray Honda Fit motorcar was seen. A woman's body was protruding from the front passenger seat. She had multiple gunshot wounds. She was taken to hospital where she was pronounced dead. Investigations that followed revealed that the motor car belongs to a JDF sergeant who is also a licensed firearm holder. He was located and taken into custody. Detectives say they are working diligently as the case progresses. Missing girl aged 4 found alive after man and woman killed. A 4-year-old girl who is believed to have been abducted by unknown attackers who shot and killed her mother and injured another woman in Spicy Hill, Trelawney on Saturday afternoon was found abandoned on a roadway hours after the attack. After the shooting, she ran and was later found by a farmer on the same road, a senior investigator told the news. The police theorized that the deadly gun attack on the women was a reprisal for the shooting death of a man in the community during the wee hours of Saturday morning. The deceased have been identified as a 38-year-old laborer, Iron Jarrett, of Spicy Hill, and the 21-year-old Tika Ennis of Boston, USA, and the refuge Trelawney. Up to late Saturday evening, the infant was in the possession of the Trelawney police, who indicated that she was not physically hurt. Meanwhile, the second woman who was shot during the attack remained in hospital in critical condition. Reports are that about 12:45, Ennis, her daughter, and another woman were walking along a lonely road leading from Spicy Hill to Refuge when they were pounced upon and shot by unknown attackers. The women were rushed to the hospital where Ennis was pronounced dead and the other woman admitted in critical condition. But family members and residents became concerned after the infant was not found. However, while the police were on the crime scene, news broke that she had been located further along the roadway. "To God be the glory," expressed a family member who was among the gathering that massed outside the taped crime scene. The shooting came about 11 hours after Jarrett was shot and killed at his home, not long after he returned from a party in his community. Reports are that about 1:30 a.m., residents heard gunshots coming from the direction of Jarrett's house. The police say his bullet-riddled body was discovered about 7 a.m. by a family member. "I don't know why someone would want to hurt him because he cannot even walk without crutches," one of Jarrett's family members contemplated. The police say the attack was linked to an ongoing feud in the area between rival factions. It is believed that Jarrett was killed because he was labeled as an informer. A police source told the news that Ennis was believed to be connected to a member of one of the rivaling factions. "We recently had a major operation in the Spicy Hill space in search of the individuals involved in an ongoing feud," Superintendent Carlos Russell, head of the Trelawney Police Division, shared. The Trelawney Police Division has now recorded 8 murders since the start of the year, 4 more than the 2 reported over the same period last year. The police reported that 17 murders were reported in the parish for 2021, 6 less than the 23 recorded the previous year. Trelawney, which tallied the second lowest number of murders across the 19 police divisions last year, was edged out by the parish of Portland, which ended the year on 15. Diplomat deployed to Poland to receive Jamaican students. Jamaica's Charge d'Affaires in Berlin has been deployed to Poland to receive the Jamaican students heading there from the conflict-torn Eastern European country Ukraine. Foreign Affairs Minister Kamina Johnson-Smith made the disclosure on Saturday at a press conference to provide an update on the 28 Jamaican students stranded amid a military attack by Russia. Johnson Smith said Charge d'Affaires Denise Seeley will be working with Friends of Jamaica, members of the Jamaican community, and the Honorary Consul of Jamaica to Poland. She will provide general support to the process, including settling the arrangements made for their accommodation and the subsistence already underway, said Johnson Smith. According to the minister, a diplomatic note has been sent by the Jamaican embassy in Berlin to the Poland Ministry of Foreign Affairs requesting safe passage for the 28 Jamaican students in Ukraine. The names of the students have also been shared with the Poland border guards. As of late Saturday afternoon, Johnson Smith said most students were in Lviv, a city 2 hours away from the Polish border. As I speak to you today, 23 of our students are in Lviv. 4 arrived early this morning and 19 by train in the last 2 hours, she said. However, she said 3 of the 22 students remain on the train based on instructions from their parents. The ministry is seeking to get further information on their final destination. Meanwhile, one student who had given her passport to Ukrainian authorities for it to be updated will be given a temporary one from the Passport, Immigration and Citizenship Agency. Johnson Smith said accommodation has been arranged for all the students in Lviv for what is anticipated to be a one-night stay before they leave for Poland. Transportation for the students from Lviv to Poland has been secured and all costs, including accommodation, will be underwritten by the government, she said. In the meantime, Johnson Smith has sought to rebuff certain comments by one student. According to the student, he and some of his peers remained in Ukraine as they were in limbo because the Jamaican government failed to engage their universities as requested about possible academic penalties in the event they left the country. What I can't explain is why these statements are being made, the embassy wrote the universities. All the universities that we got information from where students said what university they were attending, we wrote them to ask them what the arrangements were, she said. The minister also said the students were kept abreast about its interventions. She has cautioned the persons against sharing misinformation online. When I shared with the embassy a screenshot of a particular post saying we had not, the response was an expression of complete surprise because the embassy said that person knows, so why would they say that, she insisted. Court orders release of man who waited for 10 years for transcript to appeal conviction. The Court of Appeal last month ordered the immediate release of a man who had to wait for 10 years to get the transcript of his trial so that his appeal could be heard. Although Jerome Dixon lost the appeal against his conviction for wounding with intent, the court frowned at the fact that no explanation was given for the delay. Dixon and the appellate court did not receive the transcript until May last year, and the court ruled that the delay breached Dixon's constitutional rights to be heard within a reasonable time and described the breach as egregious. Attorney at law John Clark, who is representing Dixon, said last week that his client has already filed a suit in the Supreme Court against the government to get redress for the delay. He said the suit was filed against the Attorney General long before the appeal was heard. Clark also said Dixon will be taking the case to the United Kingdom Privy Council to have his conviction set aside. Dixon was sentenced in February 2011 to 15 years imprisonment for the offense which was committed in St. Andrew on September 3, 2005. According to reports, he entered the complainant's house in St. Andrew, stabbed her several times, and slashed her throat. The complainant said she knew Dixon for about 17 years before the incident. The court, in its judgment this month, could not fathom why a man who was convicted of wounding with intent had to wait for 10 years for the transcript of his trial to be sent to the appellant and the Court of Appeal. It has not been disputed that the applicant's rights as prescribed under Section 16 of the Charter of Fundamental Rights and the rights of the Constitution have been breached, the court said. There has been a period of 10 years delay between the conviction in February 2011 and the hearing of the appeal in July 2021, and the delay is not attributable to the applicant in any respect, the court pointed out. The transcript of the trial was only obtained by Dixon and the Court of Appeal in May 2021, albeit was received by the Office of the Director of Public Prosecutions in June 2014. There has been no explanation as to why there is a stark discrepancy in the dates that the parties received the said transcript, the court said. Dixon said in his affidavit that he was anxious and distressed that he had served his sentence without his appeal being heard. He said the prison authority had advised him to abandon his appeal because of the delay so the court could order his release. Attorney at law Terrence Williams, who was instructed by Clark, had argued that Dixon's conviction be quashed, but the court said it saw no basis for that remedy to be granted. Williams also argued that the delay in the hearing of the appeal amounted to an abuse of the court's process attributable to the Crown. Prosecutors Tracy and Robinson and Dwayne Green, who represented the Crown, had argued that the conviction should not be overturned. In response, the court said, "We are of the view that there was cogent evidence leading to the conviction of the applicant and that there has been no substantial miscarriage of justice that would require that the conviction be quashed." Further, the appeal, although delayed, has been heard and considered by the court in its entirety. The court said, based on correctional center rules, Dixon may have been eligible for an early release date after 2/3 of his 15-year sentence has been served, dependent on the assessment of his good conduct by the commissioner or appropriate correctional officer. By this court's calculation, this early release date would have been on February 21, 2021, and if he were to serve the full term of imprisonment, his latest release date would be on February 21, 2026. Fortunately, on February 16, 2021, the applicant was granted bail by a single judge of this court, which was 1 week before the early release date. In that event, he has not been subjected to any breach of his right nor liberty as a result of the delay in the hearing of his appeal, the court ruled. The court disclosed that it had no correspondence from the correctional services as to Dixon's eligibility for his early release. However, bearing in mind the egregious nature of the breach of Section 16(1) of the Charter, that is the right to be heard within a reasonable time, an appropriate remedy is required. In our view, the full period of time between the applicant's conviction and the disposition of his appeal should count towards his sentence, and the applicant spent 10 years imprisoned, which is equivalent to his earliest available date, should not be subjected to any further term of imprisonment, the court ordered. The orders were made on January 21 by President of the Court of Appeal Patrick Brooks, Justice Jennifer Straw, and Justice Carol Edwards, who heard the appeal. The orders were application for leave to appeal conviction and a sentence refused. The sentence shall be reckoned to have commenced as of February 21, 2011. It is declared that the post-conviction delay is inordinate and constitutes a breach of Section 16(1) of the Charter, for which he is entitled to a remedy. As a remedy for the breach, the period of imprisonment of 10 years already served by the applicant is to be treated as time served and deemed to be the full service of his release. Accordingly, he should be immediately released. Don't forget to like, share, subscribe, and hit the notification bell. Select all for daily news updates.